a redaction in order to protect this country. The DOJ was just trying to cover itself to keep the public from learning the truths about what was going on. Is that a defense? Jonathan Turley is a professor at George Washington University Law School, and he joins us tonight. Professor, it's a very simple question. Is the Department of Justice allowed to redact information solely for the purpose of protecting its own reputation?
It is not, even though it has a long history of doing so, not just in Congress, but in the courts. What's really funny is that they will charge someone who gives them misleading information, but they'll tell Congress that they've redacted classified information that proves entirely unclassified. And there is this sense of acting with utter impunity when you redact these types of documents. If you look at the language that was uncovered by Senator Johnson and his staff, that material could not be considered classified under any definition. So the question is why the committee has long accepted this type of conduct, including Democrats. They can disagree with Chairman Nunes, they can disagree with the White House, but they should all agree on the fact that this is an improper use of redaction.
And it's been going on, you said, for quite some time. So this is basically the status quo. This is not a new way of doing business.
Unfortunately, it is. I've been counsel in national security cases against the government where they have redacted material, where I've objected to the courts that it's clearly not classified. I've been allowed into SCIFs or classified settings where I've reviewed the material. And this is a recurring complaint among counsel in national security cases.
So in this specific case, you have the Deputy Attorney General, and no one disputes these facts. The characterization is different on either side, but nobody disputes that Rod Rosenstein went over to the Congress and threatened to subpoena the personal communications of members there. Have you ever seen anything like that? And what does it suggest about the relationship between the DOJ and the Oversight Committee?
Well, first of all, it really does reflect the long mistreatment of Congress. You know, these committees have not had a robust oversight record. They often roll over. This is something new, and frankly, those of us who've wanted more oversight have welcomed the last year, because finally you have a committee saying, wait, we're not just going to accept any redactions you have. We're not going to take no for an answer on something we clearly have oversight duties. Now, threatening, whether it's criminal or civil, staffers or members is clearly inappropriate. You know, I can understand that Rosenstein may felt that he was being mistreated. But it doesn't matter. You have to get over it. Congress created the Department of Justice. This isn't personal. It is oversight business. So no matter how aggrieved you may be, you cannot speak to an oversight committee and threaten those staffers with taking something like subpoenas to their doorstep.
The Congress does have oversight over the executive agencies, including the Department of Justice, correct? Or is that, I mean, you watch the other channels and you'd think that that was something that right-wingers made up last week, but that's a constitutional principle. Am I right?
No, that's absolutely right. And you really shouldn't pick fights with people with oversight power.
Yeah, I guess you shouldn't. Professor, thank you very much. I appreciate it.
Thank you, Tucker.